Welcome to a Sandra Day O'Connor Institute for American Democracy and Civics for Life conversation about the future of the court. I'm Liam Julian with the O'Connor Institute. In April of 2021, President Biden established the Presidential Commission on the Supreme Court, a Supreme Court that President Biden had previously said was, quote, getting out of whack. The commission's purpose, as the executive order put it, was to provide an account of the current debate over the, quote, role and operation of the Supreme Court in our constitutional system, and, quote, an analysis of the principal arguments in the contemporary public debate for and against Supreme Court reform, including an appraisal of the legal merits and legality of particular reform proposals. The commission was not asked to make recommendations. I'm joined today by two people who served on that presidential commission. Cristina Rodríguez co-chaired the commission. She's the Leighton Homer Surbeck Professor of Law at Yale Law School and a former clerk for Justice Sandra Day O'Connor. Adam White is a senior fellow at the American Enterprise Institute and co-director of George Mason University's C. Boyd and Gray Center for the Study of the Administrative State. Cristina and Adam, thanks for being here. Welcome.
Thank you.
Thanks.
Yeah, Cristina, there's 34 commissioners, I think. You all met over the course of several months. You had witnesses. The commissioners were largely law school professors, so from across the political spectrum, had, I assume, some strong opinions on these matters. And at the end, you put out this wonderful report, and everybody signed on to it. I'm wondering if you could tell us how that happened. You know, how you were able not only to structure the meetings, make sure everybody's ideas were heard, but how you were able to achieve that consensus.
It was all seamless, Liam. I think the commission was set up to be, I wouldn't say bipartisan, because there were people with views across the spectrum. You couldn't pin down people's views necessarily based on partisan affiliations, but it was designed to be ideologically diverse. And it was on a topic that generates a great deal of disagreement, even among people who might have the same views about the court's substantive decisions. And so I don't think that it was actually possible to achieve consensus, but the commission was not set up to achieve consensus, and we weren't tasked with making recommendations and reflection of that. But I do think what we were able to do was provide what I think is the most comprehensive analysis and presentation of, first, the leading proposals for potentially reforming the Supreme Court, and an assessment of the arguments for and against those proposals, which is a way of clarifying for people who are part of the political debate, but more importantly, for policymakers, people with actual power, what is at stake if you're going to begin to think about the role of the Supreme Court in our system of government and whether reforming anything about the court is appropriate at this time. And in that sense, we were able to achieve that objective, I think, because we had a lot of meetings in a lot of different formats that allowed the people who were involved both to articulate their views of the matters that we were tasked with, but also to hear what other people had to think. Because we were subject to the Federal Advisory Committee Act, we had to have all of our commission meetings in public. And so those were held over Zoom and were really the only opportunities for all of the commissioners to speak to each other. But under the terms of the statute, we were able to meet in smaller groups that were charged with talking about and doing research with respect to specific domains or specific policy proposals. And in those groups, there was a real testing of ideas, almost always with the utmost respect for other people's points of view. But people did not hold back in the deliberations, as you might expect law professors to do.
So those working groups, did the commissioners get to choose their groups, the groups that they wanted to be on, or the group that they want to be a part of? Is that how it worked? Or there
was an effort to assign people to groups. that dealt with proposals that they had an interest in. Some people came into the project having done research or writing before and having points of view already firmly established. I think almost everyone evolved to some degree or another in their views on the subject. But as in any group, you want people to be invested in the project. And so you want their assignments to align with what's of interest.
Yeah. Great. Adam, so when we talk about reform, implicit in the idea of reform is that something could use reforming, that there are problems or challenges. So when the commission began its work, was that one of the first things that you did, was to sit down to identify the problems that might be reformed, or how did that?
Well, I just say that the way Cristina described the process is exactly right. And she and her co-chair of the commission, Bob Bauer, deserve enormous credit. I mean, everybody who's ever been in a group project can imagine how difficult it is to run a 34-person group project. But the fact that it came together at all really was a testament to their efforts. You're right that this project didn't come out of nowhere. It was a response by President Biden to calls for reforms to the court that really preceded the last presidential election. Some of the issues were front and center in American politics already. There were calls to, some would say pack the court, some would say expand the court by adding additional members. There's a somewhat long-running debate over whether justices should have term limits rather than the kind of the near life tenure that they've had in the constitutional system from the beginning. And then there were other questions around the way the court goes about its work, the process of granting cases, granting relief in cases, and questions of the court's place in the system of politics and law in general in America. I have to admit, I can't remember if any of those topics or all of them were specified in the original order from the president creating this commission, but these were all issues that were sort of already out there in the debates. And even though I'd say in the most recent iteration, calls to pack or expand the court certainly are predominant on one side of the political aisle rather than another. For other issues, there's very interesting cross-partisan, cross-ideological debate. The debate over term limits has been going on for a few decades, and I think the first major law review article on the subject in this current iteration of debates the last few decades was from a couple of conservative law professors. And there's long been debates on both the right and the left in politics over the place of the court in our political and legal systems. And so I think one of the things that made our work interesting was the fact that a lot of these issues really do cross ideological or partisan lines, not just in their current iteration, but going back through American history.
Yeah. So the genesis of the commission did come out of the Biden administration's determination that there could be improvements made to the functioning of the Supreme Court. So I guess the problems, as we could call them, were somewhat implied. Is that correct, Cristina? Would you say that? Is that a...
I think that the existence of the commission itself is evidence that there is some deep dissatisfaction with the direction of the Supreme Court. But we did make an effort to diagnose the reasons for increased partisan polarization around the court. There are the proximate causes of the commission, which include the inability to get a hearing, much less a vote for the nomination of Merrick Garland, the confirmation of Amy Coney Barrett just before the 2020 election. But as Adam suggests, these debates over the court run much deeper in our history. But the calls for court reform by Democrats, thereby putting pressure on President Biden, are relatively recent and in response to those events. One of our contributions, I think, is to present today's debate and diagnose today's debate in terms of our current political moment, but to situate it within a long history of battles over the structure of the court and the composition of the court and the outcomes of the Supreme Court's decisions and how best to run the operations of the court are debates that have many antecedents. They often arise in times of heightened politics around the New Deal and the Progressive Era, after the Civil War, after the election of 1800, all moments of significant political turmoil. And I think it's fair to describe our moment as one of those as well, maybe not on the same order as some of those previous ones. But the point is that the structure of the Supreme Court has always been something that has been worth debating and debated, because it does relate to the bigger picture operation of our system of government, to the relationship between the judiciary and democracy, and whether the court is serving whatever its constitutional objectives are supposed to be.
Right. I found that the history in the report to be so illuminating and interesting. And I thought it was interesting too, because I could see how a person could read that history, come away with the idea, oh, we've been here before, but have very different conclusions, in the sense that, oh, we've been here before, we practiced restraint, we didn't really change the way the court is structured, and everything was okay. Or someone could say, we've been here before, we practiced restraint, and we're still having the same debates, things are not okay. So I thought that was, a great way that she presented the history to allow for different interpretations. In evaluating the reform proposals, Cristina, you used 3 criteria. One, how would the proposal in question affect the court's, quote, legitimacy? Number 2, how would it affect the court's independence? And number 3, how would it affect the court's relationship to democracy? Could you talk a bit about why you chose those 3 criteria? Maybe you could tell us a bit about what they mean. And
I think those 3 ideas or principles emerged from discussions somewhat organically. And as each group was doing its work, those ideas were in play. Because anytime you start to think about the structure of the court, you have to think about the court's role in the system. And that inevitably raises each of those principles. So the question of whether the court is legitimate is a fraught one, but at a very basic level, it I think is important to a legal system that the outcomes of judicial processes be seen as legitimate in the eyes of the people, but also be seen as legitimate forms of legal interpretation. That what is being produced is the result of legal analysis and not raw politics. Justice Kagan made this observation just last week in a speech at Northwestern Law School, I believe. Then the question of judicial independence is, I think everyone on the commission would have agreed, an important cornerstone of the separation of powers, that you need a judiciary that is independent from politics. And even if you believe that it is impossible for judges to escape politics, that they have independence from partisan politics and the decision-making of the moment is crucial. And so any form of structural change to the court, any action by Congress, which is a political body, to change the structure of the court, should be careful to preserve that independence, which is essential to a rule of law system. And then finally, obviously the decisions of the court, when the court chooses to invalidate legislation, implicate democracy. They implicate whether the representatives of the people can make the decisions about what the law consists of, or whether the court's going to thwart democratic decision making. The court is in some sense supposed to be counter-majoritarian, and it is in part of our system in order to ensure that the political branches adhere to the Constitution. But the extent to which it can accomplish that objective and preserve democracy and not undermine it is a perennial battle that dates back to the founding, and all of the struggles over court reform surface this issue. And so we were mindful with respect to every kind of reform, what its relationship to empowering democratic decision making might be, and under what circumstances it might be appropriate to insulate judicial decision making from different features of democracy. And so, because those ideas were part of all of our discussions, even among people who weren't talking to each other, it seemed important to foreground them in the report and to use those as ways of evaluating reform proposals.
That's great. I was going to ask this question a bit later, but we'll jump to it now. And it's about what Justice Kagan said this month. She said, quote, at Northwestern University School of Law, quote, when courts become extensions of the political process, when people see them as extensions of the political process, when people see them as trying to impose personal preferences on a society, irrespective of the law, that's when there's a problem, and that's when there ought to be a problem. Adam, I thought this was interesting. Justice Kagan has talked before about this, but I think previously she's tended to focus less on the public perception and more on the actual operation of the court, of how the justices go about. She does mention it here, but that quote was much more about the how the public perceives things. Yeah. And so my question is, to what extent should the court be mindful in its operations of public perception? What is that interaction there?
Yeah, and she offered these remarks both at Northwestern and then a few weeks earlier, not long after the last Supreme Court term ended, at the Ninth Circuit's Judicial Conference in Montana. And there are actually some of the themes of this were in the dissent that she joined or co-wrote in the Dobbs case, the case that everybody's watching at the end of the last term. And you're right, she's focused on a couple of things. One is how the justices go about their work. As she said in the Montana address, the judges need to go about their work in a way that's really law-like. You need to have a methodology that you're willing to stick with through thick and thin, even if you don't like the political outcomes in a given case, because that's the only way that the public can trust that you're actually operating in a law-like way. And she didn't suggest that the court needs to be a political weather vane or read the polls. She definitely didn't suggest that. I don't think anybody would suggest that. But she does point to the fact that at the end of the day, the court does operate in a democracy, in a constitutional republic. And to that end, the court needs to maintain the people's trust. As Cristina said at the outset, of course, sometimes the court is going to rule in ways that go against the majority of the public's preferences. And we need the court to do that sometimes. But the court, when it does that, is drawing on a stock of political capital that it needs to build up over time. What I found striking in a way about Kagan's remarks in all these forums over the summer is that in some ways it almost echoes Justice Scalia's dissent in, I guess, ironically or fittingly enough, one of the earlier major abortion cases, Planned Parenthood versus Casey, where he in his dissent said that the court needs to go about its work in a way that's law-like so that the people can trust that the court itself is not just an extension of politics. And I think he added, if the court is just part of politics, then there's really no point in having a court itself. I was really struck by the parallels between his concerns then, Justice Kagan's concerns now. Of course, there are differences. Scalia was, I think, less agnostic on the methodological issue than Kagan was in her remarks. I mean, she has her methodology, but in her remarks, she said, the point is that the judges need to each pick one and stick with it. Scalia famously picked his and was not very shy about it. But the last thing I'd add is that in many ways, Kagan's remarks and Scalia's remarks, they go back to the very beginnings. As Cristina said, we've been debating this from our very founding. And in that opening defense of the Supreme Court, Alexander Hamilton's Federalist 78, he touched on both of these themes too. He said that the court would legitimize itself in terms of the way it goes about its work, but also in the way that the public sees its work, see the court doing its work. And so you've always had those two factors in play, and the timeless challenge is how the court should be mindful of that and do its job as a court, while also being careful not to be too political, because ironically, if the court goes out of its way to build up political support the wrong way, then it undermines itself politically and to that end in terms of its own legitimacy.
Yeah. I want to get to the reform proposals here, but I also want to stay on this subject just a little bit longer. It's really interesting. Cristina, one of your fellow commissioners, Lawrence Tribe, wrote a piece in the New York Review of Books not long ago, where he was critical of Justice Breyer's latest book. And what he essentially said was that Justice Breyer has this faith that justices are acting non-politically. And Lawrence Tribe said that's not true. That when we talk about different methodologies that justices are using, what we see is that really this is just politics masquerading as legal methods. So I guess my question is, to the extent that you feel comfortable weighing in on this, what do you think about that? And if Tribe is if he's right, if that's truly the case, then what is the reform for that?
I think it's very difficult to take politics out of judging at the level of the Supreme Court, at least with respect to the kinds of decisions that generate public debate and public outcry, because they don't tend to be technical questions. They tend to be questions of constitutional principle, and how we understand the application of constitutional principle to the debates of the moment has a lot to do with our political preferences, our more general ideologies, and not always with methodology. I think that part of what Professor Tribe might have been pointing to is that methodologies that are offered as neutral means of deciding difficult questions of principle are often chosen because they tend to produce outcomes that align with the set of moral or political priors, or that they're not actually applied in a consistent fashion. And so this is something that came up this term as well in a statutory case where I believe in dissent Justice Kagan says a majority that purports to be textualist is not actually being true to the text of the statute, because it believes that what in this case, it was the Environmental Protection Agency, had done with those words of the statute were inconsistent with what they believed it was conceivable Congress could have wanted in enacting the statute. And so when you start to see methodologies used in ways that look inconsistent with them, it is hard to escape the idea that it is views about consequences or views about what it is conceivable a Congress might have wanted aren't driving the decision making. But what I would say in the end about that is that that's not necessarily something we should lament at the level of Supreme Court decision making, because again, a lot of their cases are not cases of technical legal interpretation that can be resolved through a methodology that you decide ex ante to apply. They do require judgment. They do require judgment that's grounded in principle and views about how the world works, and in views about how a judge ought to try to take account of consequences. And it's for that reason that we fight over who's nominated to the court, because that judgment really does matter. And to suggest that it doesn't is to presume that anyone with the proper training could sit on the court and come to the same conclusion as everybody else with the same kind of training. And that's just not what Supreme Court decision making is about. And it's not that I disagree with Justice Kagan's view that judges and courts should be perceived as and should understand themselves as engaged in legal interpretation as opposed to partisan politics. It's just that interpretation blurs with or fuses with questions of principle and consequence that mean that the outcomes are going to be politically fraught.
Yeah. Adam, what do you think?
Well, I don't think any of the justices is doing or isn't even subconsciously doing just crass partisan politics. I just don't think that's true of the court. Chief Justice Roberts wrote the majority opinion in the EPA case that Cristina mentioned. Since I focus mostly on administrative law, that was a big case for me that I had my eye on. Chief Justice Roberts wrote a very similar opinion at the outset of a case called King v. Burwell, which was where he wrote for a majority that upheld the Obama administration's administration of a sort of a complicated part of the Affordable Care Act. And the same major questions doctrine, that, as it's called, that Chief Justice Roberts applied there, he applies at the beginning of that EPA case. I think oftentimes the partisanship is kind of in the eye of the beholder, but I do agree completely that at the end of the day, the justices bring sort of underlying principles to their view of the law. Nobody is born, and thank goodness, nobody's born a fully formed lawyer. We all arrived at the law because of other interests, whether it's politics or something else. And of course, those things are always going to be there kind of in the background, helping to form one's view of the law. And the question for judges then is, how do they apply the law faithfully, knowing that each of them comes to this from a somewhat different perspective? And as Cristina said, often the things that bring you to the law or inform your interpretation of the law, they go to the heart of what it means to have our constitutional republic, one sense of what the Constitution means, and also one sense of the court's role in applying the Constitution. And that was as true in John Marshall's time, right, as in ours. Chief Justice John Marshall, when he was issuing decisions like Marbury versus Madison, McCulloch versus Maryland, Gibbons versus Ogden, these went to the heart of what it meant to have our Constitution in his time. They weren't necessarily partisan or political, but they certainly came from first principles, and they did have, of course, political ramifications in any given case. And so in that sense, I agree. Of course, the court has a political impact. I just don't take nearly the same dim view of the current court that our colleague Professor Tribe does.
Right. So in this case, really, I guess what you and Cristina are saying is, yes, politics plays a part, but it's not partisan politics. It's more of a personal, political sort of the beliefs that you come to your interpretation of the law with, in that sense. Was that sort of an accurate way to think about it?
Yeah, I think that's fair. And I think sometimes those personal principles align with the political agenda of a political party. Again, that's why there are great political fights over who's nominated to the court that have grown more intense over the last several decades as the parties get farther and farther apart. But it is difference of principle and politics, and not the desire to advance the goals of a party or something of that sort.
Okay. And I'd add, in some ways, the court in its last 25 years is less political in the sort of low sense of politics. I just finished reading this wonderful new biography of Felix Frankfurter by Professor Brad Snyder of Georgetown. It's an amazing book. It's very thorough. It's 700 pages. But a lot of it is about Frankfurter, writing memos to President Roosevelt on Supreme Court stationery. We've had justices who left the court to run for president and then come back. That was Hughes. We had one justice, William O. Douglas, who wanted to run for president probably while he was on the court. And I think the aforementioned John Marshall, didn't he still serve as Secretary of State? He wrapped up his term as Secretary of State while he was on the court. I think the court has done a much worse job over the years of blending politics and law than it does now that the court is basically staffed by 9 professional judges. I'd say the one difference, though, from that time to ours, or one of the differences, is that our political debates have really polarized around the court and even around judicial methodology. I mean, it would have been unthinkable 50 years ago to say that Democrats and Republicans were polarized over the kinds of tools a judge ought to use in interpreting the Constitution. I mean, that would have made zero sense, 70 years ago. But the fact is that because you saw in the last, I guess now 40 years, constitutional originalism and textualism, arise as a response to the Warren Court, and then really become adopted early on as sort of the conventional jurisprudence of conservatives and Republicans. It had a polarizing effect among everybody. Republicans became more textualists, and I don't want to speak on behalf of Democrats, but I think that Democrats became at least more aware of textualism and originalism, and it's not nearly the sort of party line that it is in conservative circles, and so that has had a sort of a weird effect in the dynamic between law and politics. But that's partly about the parties polarizing around the court, and not just the court polarizing the political parties.
Let's talk about some of the reform proposals. They're the headline-grabbing ones, I suppose we could say, were the proposal to potentially expand the number of justices, increase the number of justices on the court, and also term limits for justices who now are really just basically serve as long as they'd like. Cristina, could you maybe give us a little bit of the pros, the cons, what you talked about with these 2 reform proposals?
So I think the debates over those 2 proposals were very different. The commission was very divided on the question of court expansion or court packing, even down to some people insisting you had to call it court packing and invoke the FDR period and the reaction to his effort to pack the court, and others who say you have to use the term court expansion, otherwise you are implying by your language that it's an improper or illegitimate method of addressing the court. My one regret about the report is that because of the deep disagreement on this issue in particular, we weren't really able to analyze the claims made on either side. We basically lay out what each side would say about why it's important to expand the court at this moment, or why it would be very dangerous to pack the court at this moment, without digging into whether there are faulty empirical assumptions on either side, or whether the proposal in favor of court expansion would in fact achieve the objectives it was addressed to, and whether in fact even proposing court expansion would lead to the demise of the court's legitimacy. I think that on the side of those who favored court expansion, there's a concern that this particular Supreme Court is not only producing decisions that undermine longstanding precedents in areas that protect individual rights and principles of equality, but that a lot of its jurisprudence related to the democratic process itself is in effect making it very difficult to change who controls the political process in a way that is advancing the interests of the Republican Party and Republican voters. And without the expansion of the court, you will lock in a political coalition that would make it impossible for there to be the back and forth through the democratic process in the principles that determine the outcome of Supreme Court's decision making. On the other side, I think the view is that if Congress were to expand the court at this time, it would be obvious that it was being driven by displeasure with the outcomes of a conservative majority court, and that has a delegitimating effect on the court because it's suggestive of political interference with the decision-making of the court, and that in many cases, even the suggestion of expansion or packing is itself a threat to the court's legitimacy. Even those who are opposed to court expansion, and this is true of some of our witnesses as well, would say that there might be some moments where the court has gone so off the rails that there's no choice but to expand the court to kind of right a ship. But there's deep disagreement about whether we're at that moment or whether the moment that we're in is just reflective of the deep differences in viewpoint that people have about big issues like abortion, affirmative action, economic justice, those kinds of decisions. There was a similar kind of debate with respect to term limits. So I don't think on either side of that debate was there a view that engaging the issue was itself legitimating or delegitimating of the court. Perhaps Adam can talk a bit about the term limits debate, because I think he's a person in particular who changed his view over the course of our decision making and deliberation about whether that would be a good reform for the structure of the court.
Yeah, I did change my mind on that. Not so much on court expansion or court packing. I mean, when I was invited to join the commission, my views on it were pretty, clearly stated. And honestly, that part of the report does kind of read like a divorced couple still living in the same house. They're having two very different conversations. But it was, even there, I thought we did as good a job as we could to put both sides' views out there in their own words as fairly as we could. And it's funny, even in the history part of that report, you can have debates over what actually happened in 1937. What happened before that? There was an interesting sort of footnote debate somewhere in there about, when Lincoln added and Congress added a 10th justice after the Civil War. Was it for sort of court packing purposes, or was it because of the fact that they had added another circuit out west and they needed a circuit justice? That's how sort of how a lot of those historical debates, it's almost impossible to not see them through the lens of contemporary politics. And just one last thing, I think one reason why that issue was so fraught politically was because, in a way, maybe ironically even, court expansion, court packing is the thing that could be achieved most easily procedurally through politics. There's the Constitution doesn't specify the terms for or the number of justices on the court. They leave that to Congress. And so by legislation, Congress could add seats to the court as it has in the past. Now, with term limits, of course, that's more constitutionally complicated because of the fact that the Constitution indicates, I think very clearly, although there's some debate, but I think very clearly that a justice, once confirmed, serves for life unless she or he retires or is impeached. We still had a pretty thorough debate over whether it'd be worth amending the Constitution to add term limits. And I did come to the debate thinking maybe there is a time now maybe now is the time for term limits. Justices serve much, much longer than the founders probably anticipated. That means that the court plays a much bigger role in society today and in our political debates, which means the stakes of each nomination and confirmation is much, much greater than it probably was at earlier stages in our nation's history. So I was sympathetic to it. What actually got me to change my mind and decide that this was a bad idea was as we delved into the process that this new term limit regime would entail, it becomes very complicated. What I mean by that is, under the current Constitution, the president nominates a justice and the Senate gives its advice and consent or not. And if it does, then the president makes the appointment. Well, if we had term limits, say 18-year terms for each of the 9 justices, that means a new vacancy every 2 years, which I think was pretty clearly intentional. The idea would be spread these out evenly over each presidential term. So 2 vacancies for every 4 years. Well, then what happens if the Senate decides not to confirm a nominee for any reason? And obviously, as Cristina mentioned earlier, that's been a real issue in recent years with Justice Garland, or would-be Justice Garland, and with judicial nominations at the lower courts before that. And I'm an advocate for the Senate having a strong role in this. Well, the first law review article I ever published was on that subject of the Senate's role. And the more we talked about the issue, the more I realized that imposing term limits on this aspect of our courts, on the justices, and spreading it out evenly over presidential terms really would push to the logical conclusion of the Senate's role being reduced. Because otherwise, the risk would be that the Senate could hold open seats and sort of stockpile vacancies for the next presidential term. And of course, that's an issue already, but I think that it would become even more so under a term limits regime. And so, forced to choose between judicial term limits and keeping the Senate's role rather than outsourcing judicial confirmations to another body altogether, I stuck with the Senate. I think that we need Congress more in our constitutional processes, not less. But at the end of the day, my change of mind then really had less to do with, whether it would be good to get people off the court after 18 years, get new blood on, and it really had to do more with the need to preserve the Senate's institutional role.
Okay. Yeah. Cristina, what are your thoughts on that, on term limits?
So I support a constitutional amendment to limit the terms of Supreme Court justices for many of the reasons that are articulated in the report. Though I think this question of the role of the Senate and whether it's possible to break the potential pattern of the Senate refusing to confirm is a really serious question, and one that would have to be resolved as a matter of design. But also the main reason that I would support this change to the Constitution that's articulated in the report is that, at least in the proposal that the Commission took most seriously, which is 18-year terms, as Adam suggested, that would mean that each president would get 2 nominations per term. And what that would mean is that you would have a closer connection between the personnel on the court and the outcomes of the political process. So you would have, on the one hand, justices who have 18-year terms, which is a long period, not subject to any electoral constraints, independent from day-to-day partisan politics, but they would be responsive in some sense to political coalitions over time, so that at any given moment you would not have a Supreme Court that was so badly out of whack with the outcomes of the political process. And you would also avoid consequences or events like one president in 4 years getting 3 nominations to the court and another president in 8 years getting only 2 nominations to the court. There's too much of a disconnection between who's sitting on the court and who's succeeding in the electoral process. And term limits would be a way of harmonizing the interest in judicial independence and the importance of the court having some connection to public will, not the polls of the moment, but to public will. I think one of the contributions of the report for the long-term debate, and I think of this report as something for the ages, I hope, is that it does present the institutional questions that have to be answered. It's not enough to say, I think term limits are great because for justices to serve for 35 years makes no sense. You have to understand what it would entail to actually operationalize a system like that. And one of the things that it would entail is to do something about the Senate's role in the process. So the Senate can't thwart this regular turning over of the justices that term limits contemplate. And so I do hope that as people talk about reform in the future, perhaps not in our lifetimes, but into the future, that the questions that were raised by the report about the design features that you would have to take into account will get attention and will be a basis for people to come up with default rules and other ways of addressing some of the challenges associated with dramatically changing our system from one of life tenure to one of term limited justices.
Cristina, yeah. Liam, could I maybe add one more thing on that? I don't want to get greedy with our time here, but something that Cristina mentioned actually raises another good point. One of the things that's really made term limits, I'll put it another way, this idea of vacancies, more vacancies for one president versus another, a lot of that goes to justices pretty clearly timing their retirements to coincide with who's occupying the White House at a given moment in time. And that too has a bipartisan flavor. It's justices now pretty reliably, if they can retire at a time of their own choosing, they choose to retire at a time when they think the president will appoint somebody who's a lot like them. And I can understand why they do that. And I suppose if I were a judge or a justice, I'd have the same instinct. But it's no way to run a country, because it does create this, it reinforces this image of each justice as being aligned with one political party, right? The first image we see of a justice is she or he getting nominated by a president. And the last image we see of that justice is generally he or she standing next to the president who that justice has chosen to pick his successor. And that's not a good look, I guess is a way of putting it. And I worry about that. I don't think there's a way that it's, I don't know how Congress could solve that outside of term limits, but I think this is an area where we really do need to demand that the justices sort of become the best version of themselves and stop doing this whenever possible. One thing I do worry about, though, with term limits, one more thing I guess I'd say is I agree with Christina's point that it does start to look weird when one political party is responsible for appointing more justices than the other in a way that's disconnected with election results. But I guess what really zeroed me in on my worries about this issue, the term limits issue, was that we tend to think about this in terms of presidential politics, right? The president wins elections and therefore he gets to appoint nominees. I made a joke during one of our hearings, or I tried to make a joke. I said we treat seats on the court like we do couches in the Oval Office. After every inauguration, you deliver 2 new ones. And I'm not a fan of that, honestly. I think that, of course, the justices, they are appointed as the outcome of political results, but I worry about us focusing so much on presidential politics to the exclusion of congressional or Senate politics. And so that was another way of sort of expressing my general concerns about the judicial appointments being identified so closely with presidents more than with politics more generally.
Yeah. Adam, to the point that you made about retiring, justices retiring, you wrote a separate statement to this report. In that statement, you wrote that the court's legitimacy, quote, requires much of the justices, our elected leaders, and the American people ourselves. For all three, the most important reforms will be self-reforms undertaken with a spirit of self-restraint. So that's, I guess, what you're talking about with the justices sort of when they retire. But could you talk a little bit more about this notion of self-reform, self-restraint? And especially given that, I mean, I don't think this is an original opinion. We're not necessarily in a time where self-restraint is in vogue.
Yeah.
So maybe you could tell us a little bit more about that.
Yeah, I guess this part really was writing for the ages and not for the moment. And you're right to say it's not just about the courts. And this is something I've been writing about here and there for a few years, about how we often think of our constitutional system as, checks and balances and ambition counteracting ambition. But a lot of the founding vision for this country involved self-restraint on the parts of all three branches of government. And surely, no less for the courts, maybe mostly for the courts, to really take care to restrain themselves in the right ways. And so I thought about this a lot during our work. Actually, I have a new article out in a political magazine. It's called Commentary, where I reiterate this theme. I raise questions about the way that the justices grant cert in cases, the way that they do or don't grant preliminary injunctive relief in cases, the so-called shadow docket, the things that justices say in concurrences or dissents where they invite future litigation or when they invite future legislation. These are all places where I wish the justices, all judges, would constrain themselves much more. So I do worry about this a lot, and I think it goes to the general tenor of our politics more generally, or government more generally, where people in each of our governing institutions really are pushing their powers to the brink. And partly we try to correct that through checks and balances, and partly we try to correct that through elections, although that doesn't work with justices. So the question is, how do you appeal to the better angels of the justice's own nature and urge the court to become a better version of itself? That's what I was trying to do. I was in the end of our work. I was grateful to my fellow commissioners for affording us the opportunity to do that. Some of us did that. Some others wrote op-eds. I really wanted for my sort of closing statement as a commissioner to be in the form of the official work of the commission, and that's why I did it as a separate statement.
I see. As we sort of kind of close out, there are a lot of other reforms in here, and I would really encourage our audience to go to the report. I agree, Cristina and Adam. I think for many years people will be reading this report. It is wonderful. I'd like to sort of close. Linda Greenhouse, a longtime journalist covering the Supreme Court, she had written an article about the commission and its work, and she wrote that one thing that she took away from the witnesses was that the legal academy has lost faith in the Supreme Court. She wrote, quote, "Across the span of American history, the Supreme Court has most often been the obstacle to progress. As some witnesses to the commission emphasized, for reasons of practice and structure, it is highly likely to remain so." I'd just like to get your comments on that. Both of you obviously are part of the legal academy. Have people just lost faith in the Supreme Court? Have you lost faith? I doubt it if you served on this commission, that you must think that this is an institution that is worth reforming, can be reformed in some ways, is durable, or maybe you don't.
So I think constitutionalism is important. It's something that needs to be preserved, and the witnesses who spoke to the role of the courts in preserving constitutionalism, which is the existence of restraints on the political process, had much to offer. I do, however, think that it is important to constantly consider the relationship between the court and the democratic process. And to that end, there is an important chapter in the report that talks about ways of recalibrating the court's role in the political process to disempower it. And even though term limits and court expansion have received the lion's share of the public attention, in part because they offer reforms that are clear in what they would look like, these so-called disempowerment reforms are worth taking seriously. And among the reasons is that at bottom, they are about the importance of Congress playing its own role in the development of constitutional principle and constitutional culture. And Congress has a responsibility to assert itself in that sense. And so to think about ways in which Congress can respond to decisions by the court that offer the alternative that the people's representatives believe to be the better interpretation of Congress's authority to say advance voting rights or some other similar objective. I think the problem with the whole court reform debate is that a lot of what advocates for court reform think court reform will solve is actually not the problem of the court, it's the problem of our political culture. And I think that sometimes people who emphasize the anti-democratic consequences of what the court is doing have a romanticized view of the political process and expect more than our current Congress can deliver. And the themes of polarization that we've talked about throughout this conversation make the process of Congress asserting itself in the constitutional dialogue just as fraught as the court doing the same. And so there's no easy answer to these debates that we're having. But I do think that it is vital that we think about whether the court is exercising more power over democratic processes than it ought to, and think about a Congress capable of responding through the articulation of constitutional principle.
Yeah, and just for our audience, the structural, the reforms you're talking about are to restrict the Supreme Court's jurisdiction, to impose supermajority voting requirements or require courts to give deference to legislative judgments about constitutionality, and to authorize congressional overrides of some judicial decisions. So those are what you're talking about when you're talking about weakening the court's power. Again,
exactly.
I would have the audience go to this report and read about this. It's all very interesting. So Adam, we'll close, I guess, with you and your response to Linda Greenhouse's quote and just generally the future of the court.
Sure. I wish Cristina would have had the last word because she's, in some ways, more positive than me. I would say, at the outset, I definitely haven't lost faith in the court, but in some ways, I think it's because I put less faith in the court to begin with. In some ways, right? I think some who have lost faith in the court are losing faith in the court now. They're disappointed that the court is less of a bulwark on certain issues. I mean, obviously, most famously abortion, but in other issues too, where they wanted the court to do more than it's going to do. And in some ways, they wanted the court to stand athwart political majorities in a way that the court's not going to do anymore. I always had wanted a more restrained court in many ways, and a more self-restrained court. And so in some ways, the court, frankly, is moving in a direction that I like. So I'm more and more faithful every day. In some ways, the criticism of the court now reminds me of the criticism we saw from political conservatives in the early 90s, where a number of them rose to declare the court illegitimate in the aftermath of Planned Parenthood versus Casey. And I didn't agree with that then, and I don't agree with that now. I think one of the challenges, to get back to maybe the beginning of our conversation about the legitimacy, is that most Americans don't follow these issues on a day-to-day basis, and nor should they. They should be living their own lives, and they should vote, and they should take interest in these things. But we don't want every American to be a lawyer on a day-to-day basis. But that really puts, responsibility first and foremost on the court itself and how it describes and explains and justifies its work. It also puts a lot of responsibility on folks like me and Christine and Linda and others to try to convey the court's work, fairly and even-handedly, even when we come back and criticize it. And I'll continue to criticize the court on any number of things too. That's a very difficult balance for people around the court to strike. And in some ways, I think the reason why the debates around the court are becoming so heated is that the people closest to the court are sometimes the most sort of over the top in our praise of it, our denunciations of it, and so on. And that's bipartisan, and it's not just in the last few years. That's a sort of a long-running issue. But I guess that's a long way of getting to my point, which is if I'm losing faith in anybody these days, I'm probably losing faith in the people around the court in the ways that we talk about it. And so I feel like the area that needs the most sort of effort and self-restraint is those of us who are going to be celebrating or denouncing the court in the years ahead. I think those of us who are inclined to praise the court right now need to be a little bit more circumspect and careful. And those of us who are, inclined to denounce what the court does, they hopefully will take the same sort of pause and so on. And maybe, I guess that's a long way of saying self-restraint begins at home, and I'll do my best.
Yep. In a time when civil discourse has never been more important, the work that you did on the commission is what a great example, and just the dialogue that we're having here. So thank you for your service on this commission. I agree. I think people will be reading this report for a very long time. And thank you for taking some time today to talk to us about it, Cristina and Adam.
Thank you for bringing us together. It was
my pleasure.
A good experience.
My pleasure. And again, all credit to Cristina and Bob for what they managed with the commission. It was really made our work a lot easier. And I'm still grateful for that.
Thank you.
All right. Thanks.